things applying for and obtaining a number of the search warrants in the case. You know this because you heard extensively from Detective Murphy during a lengthy motion to suppress hearing that we did. I believe that was in December of 2015. And we've got the transcript here. Obviously, the issues at a motion to suppress are very different than the issues at trial. At a motion to suppress, for example, there's questions about probable cause, sufficiency of the search warrants at issue, those types of things. And I've talked to Murphy. He did agree to speak with the defense, and he shared with me some of the topics that they wanted to cover. And basically, Judge, he shared that a lot of the topics were the same things that we've already litigated during the motion to suppress, including the validity of the search warrants and what was told the magistrate court. By the way, though Murphy did interview some of the witnesses, he did not interview all of the witnesses. Much of the information he provided to the magistrate court was actually hearsay information that he got from other detectives. Under the collective knowledge doctrine for a motion to suppress, that's perfectly permissible. It's a different story when you get to court in front of a jury, though, obviously. We have rules of evidence that apply and would prevent him from simply regurgitating what all other detectives and other witnesses may have shared with other police officers during the course of the investigation. So, obviously, Detective Murphy can testify about things he actually did and has personal knowledge of if the proper foundation is laid. Our concern is that this is going to be an attempt to get into things that would otherwise be impermissible in terms of his obtaining search warrants and those types of things. So I provided the court with a copy of the motion in limine as well as the authority that I've cited therein. As a threshold matter, I want to point out, I know the court's aware of this, that the rules switch when you're calling a witness, that you have to keep him on direct examination. He's not, there would not be subject to cross-examination by the defense, but arguably if he were subject to cross-examination, there's at least an argument that can be made that within permissible bounds you could have a little more latitude than if he were on direct examination. But that's not the case here. He would be directed by the defense, and obviously they would be bound by rules of direct examination. We would be afforded the opportunity to cross-examine this witness because he's being called by the defense. Nonetheless, I put some authority in there that dealt with what can happen if he were called as a state's witness and what would be a permissible scope of cross-examination, which again would be arguably a little more flexibility, a little more latitude for that situation because you are in some instances allowed a thorough and sifting cross-examination. So I cited Smith versus the state, which is 251 Georgia Appeals 32. That's a 2001 decision. And in that case, the defendant wanted to question the warrant's validity and ask things about what was included in a search warrant. And to quote Smith on page 2 of the document I gave you, however, resolve questions of a warrant's validity as a matter of law, and the defendant's inquiry before the jury was irrelevant. The right to a thorough and sifting cross-examination is not a bridge where the excluded testimony will be based upon speculation or hearsay, and went on to affirm that conviction and hold that it was perfectly proper for the court to limit cross-examination. We're not even talking about that. We're talking about direct here, about the validity of a warrant and information given to a magistrate judge because it would be impermissible hearsay. Similarly, I cited White versus the state, which is 225 Georgia Appeals. It's in 1974. It's a 1997 decision. And in point of law number 8 on page 3, there was an issue raised, and here's what the court went on to say. The trial court did not abuse its discretion in prohibiting White from challenging each fact contained in the search warrant on, again, cross-examination. We're dealing with direct here. The court resolved the question of the warrant's validity as a matter of law. White's inquiry before the jury was irrelevant. So they went on to say that that was not a permissible line of questioning for that witness. Nelson versus the state is the next case that I've cited for the court. 188 Georgia Appeals, 244, 1988 case. On cross-examination, appellant sought to question the officer concerning the reliability of a confidential informant. In his sole enumeration, appellant urges that this right to a thorough and sifting cross-examination of the officer on this issue was erroneously restricted by the trial court. And then in the bottom of the last paragraph of the case I provided the court, Appellant was merely prevented from eliciting inadmissible hearsay and legal conclusions from the officer. The right to a thorough and sifting testimony would be based upon speculation and hearsay, and they went on to affirm that denial. And the final case that I have for the court is in similar vein. It's Cody versus the state. It's 222 Georgia Appeals 468. That's a 1996 case. The trial court did not err by refusing to admit documents during cross-examination of a witness who had no knowledge of the documents. So we would object to trying to introduce information that might not be outside the scope of the personal knowledge of this detective. Based on what the detective has shared with us, these are topics that we have reason to believe the defense wishes to go into, and rather than raise these serious objections in front of the presence of the jury, we thought it more prudent to file a motion in limine so that we could articulate for the court what we think the problematic areas would be when Detective Murphy testifies. Certainly don't have any objection to asking, did you send a preservation letter? Did you do certain fact things where they can lay the foundation for it? We're very concerned, though, about them trying to get into hearsay statements that other people told him that served as the basis for the search warrant as was presented to this court during the motion to suppress hearing. And therefore, we would ask that you grant our motion in limine regarding those topics.
Aaron, thank you so much for giving us the opportunity to review this over the lunch hour before we had to address it with you. And I do appreciate the state's addressing this in this manner, so we're can hopefully have a smooth production of the case. What I will say, first of all, with regards to calling Detective Murphy and allowing us to question him, we do expect the court to follow the rules that are set out by the official code of Georgia, that being 24-6-611, which allows for a party who calls a hostile witness or an adverse party or a witness identified with an adverse party to interrogation be made by leading questions. That allows for the effective and efficient moving of the process. So we believe the court will follow the law of the state of Georgia, and that law is that Detective Murphy, who is a party, a police officer, the Cobb County Police Department, that is the adverse party in this case to the defendant, Mr. Ross Harris. And while I'm hopeful, and I don't anticipate him being hostile, I do think there'll be some questions that will be more properly put to him in a leading fashion so that we can move forward, which I know the court wants to be able to do. So to the extent that we want to follow the law, we encourage the court to in fact do that. As to the validity of the search warrants, again, we can only thank the court for giving us a very wide latitude in dealing with those issues back last year. We've done that. The court has ruled upon that. We're not revisiting the validity of the search warrants. Despite the concern the state may have, that simply is not the point of this jury. We want to stick to the matters before this jury, which are what was the investigation in this case, and in fact, what is the credibility of the officers who are involved in this investigation and what they've been testifying to before them these past several weeks. So to that end, we are not addressing the validity of the search warrants. Certainly Detective Murphy, as the court knows, was greatly involved in obtaining search warrants. That was a large part of what he did. And I do anticipate we'll ask him several questions about things that he did in that regard, both in the preparation, the obtaining, and the execution of those search warrants. I don't believe there's anything whatsoever off limits in that regard. As long as we're not trying to address the probable cause element, we understand. That's a legal issue that's been ruled upon by the court. But as it relates to what he specifically said and told magistrate judges and witnesses and fellow officers, that certainly is not hearsay, it's not inappropriate, does not go to the validity of the search warrants. So to that end, we anticipate following a examination which delves into those particular issues. And if there's something that crosses that line or goes afield in some way, then I'm sure the state will bring that to the court's attention, make the proper objection if need be. And if we've crossed that line, then the court will certainly shepherd us back into the right place. But as it stands right now, we believe we are, because the defense's case is founded not only in the innocence of Mr. Harris who is charged, but also in the credibility of the officers who are testifying against him and how they've taken this case. This examination will address those specific issues. That's what we want to be able to ask him about. That's what the law allows us a thorough and sifting cross-examination of. And to the extent that anything that might involve what someone else told him, Frankly, it's not being offered for the truth of the matter, and I anticipate much of it will not be truthful that may have been provided to him. But nonetheless, our only addressing of any of those issues, in the limited extent we will, is to explain his conduct and what he did in going forward in investigating the case. So for all those reasons, it would not be hearsay, would not be inappropriate, and falls within the rules set out by the state of Georgia.
Well, it's two-pronged in its nature, the motion in limine. It says that the first prong, whether the defense, upon calling this witness, has to use a direct examination style, or if they can lead. If you're a witness, you called them, you can't lead. If you lay the proper predicate for that to change, you can make, until you have, you can ask to do so, and I'll take argument and decide. But just from the get-go, no, you can't call them and just leave. As to the other issue regarding hearsay and search warrants, do you have a response?
I do, Judge. This has already been litigated. The exception that would apply to, whether you can talk about the basis for the search warrant and collective knowledge applies only in the pretrial motions hearing. And I'll point out the case that we cited for the court of note that the defense has cited none, White versus the state, where the court has resolved the question of the warrant's validity as a matter of law. Defendant's inquiry before the jury is irrelevant. And in the similar cases that we talked about, there are issues involving hearsay statements that were told to the detective. That haven't been articulated any exception to those hearsay statements that the detective doesn't have personal knowledge of. Basically, Murphy was sitting at a monitor applying for search warrants on EWI based on what other officers had told him and not his direct investigation of the case. Any of that information that was told to him was hearsay. And they can certainly call those witnesses. They can call a witness who saw or observed things, just as we've done in our case. I have no objection to them calling that person, but to go into statements that he may have heard from other people, it's flatly hearsay, even though it formed the basis of a search warrant. And Judge, the issue for the issuance of a search warrant, whether it's probable cause, is a very different issue than what you have when you get to trial. And you've already resolved that legal issue about the sufficiency for the basis of the search warrant. Those rules of hearsay are a little bit more lax when you're at the motion to suppress level, because officer conduct is directly relevant to the obtaining of those search warrants and whether or not there's probable cause. But I expect that the testimony from Sean Murphy would be, I didn't participate in the defendant's interview. I don't know what the defendant said. I didn't participate in interviews with Leanna Harris. I didn't participate in interviews with most all of the witnesses in this case. There are some witnesses who have testified, Janie Meadows being one of them, who, maybe they could get to a point where they could lay some sort of foundation for that, but we haven't gotten that point yet. And that's a different story, because if they can lay a proper foundation for those witnesses, then that's fine. But most of the cases for the search warrants that are at issue are statements from other officers who in turn got statements from other witnesses. We're talking hearsay within hearsay, and it would just simply be improper in front of the jury to call a detective who has no personal knowledge about these things and has not interviewed those particular witnesses to ask what he told the magistrate court and what the basis of that was. That's an issue for the motion to suppress, but not an issue for the trial. And you can't just call a witness for the purpose of saying you're incredible. I mean, you can call a witness to say, well, all right, what do you have personal knowledge about? But the law is pretty clear that you just can't call somebody to say, all right, well, I want to call your credibility into issue, so I'm going to call you to the stand and ask about all these things that you heard from other people and relate to a magistrate court. But that's not the proper basis for doing that. Those things might be issues that need to be resolved at the motion to suppress hearing, and they were. We litigated that in length. I think it was a 2 or 3 day hearing, as I recall. We called multiple witnesses. If they want to call some of these fact witnesses, we provided our witness list. We've given the supplementals. We've given the recordings of their interview. Have no problem with them calling these civilians that may have passed things on to police officers. Have no problem with them calling police officers that might have firsthand knowledge about things. But it's merely going into this evidence. using Detective Murphy because he happened to be the one that was tasked with getting the search warrants in this case would be entirely improper to do in front of the jury. And we stand by the authority that we've cited for the court. Again, point out the defense has not cited anything. We believe that that's an accurate statement of the law, and the appropriate way to handle this issue is to deal with it outside the presence of the jury, so we're not making these long-winded standing arguments in front of them, which are entirely valid.
Well, I'm going to grant the state's motion in limine.
Your Honor, we'd ask to provide a proffer to the court then as to what the testimony would be. The question would be asked.
Go ahead.
And we would call Detective Murphy to explain his role as the second detective in this investigation as to how that came to be, how he became in that position, what that position means, what his role is in being second to the lead detective in the case.
Oh, that's fine.
Well, I've been told I can't. You've granted their motion to preclude me from calling him, so I'm proffering what that would be.
Excuse me, I did not grant any motion precluding you from calling him.
Okay, well, then maybe I'm missing what the court said then. What are we not being allowed to question him about?
Going in underneath the search warrant and about hearsay.
And I'm not sure what hearsay the state's referring to there. What we anticipate calling him for is to talk about his statements, his specific statements to the magistrate, his specific statements to witnesses. The state has suggested that we were going to try to be getting out other statements of other people. Frankly, I don't know that there are many of those at all outside of a couple of detectives maybe. But our questions would be pertaining to what did you tell the magistrate, and as to explaining his conduct in doing that, if in fact he got information from someone else, or in fact he doesn't even know where he got that information from, that is not hearsay. That is it is being offered to explain his conduct and why he did what he did. So to that end, that's my understanding of what they're suggesting, and so we simply want him to be able to come testify and tell us exactly in his role as the second in command, if you will, as second detective. What was your role? What was your task? What in fact did you do? What in fact did you tell the magistrate? And if in your own personal knowledge, either one, you knew otherwise, or two, you lacked any personal knowledge to be swearing under oath to the truth of these matters, then that goes to this investigation. That goes to, in fact, exactly what he did in his role, and whether or not he was directed to do that by others who were superior to him. Frankly, he could be used to impeach the witnesses that the state has called if they have testified to one thing that is, in fact, not his recollection or his memory of exactly what did occur. So to that end, that's what I want to be able to call Detective Murphy to explain that situation. It will include talking about, our proffer would be that he would testify about speaking to the magistrate about several statements that have been claimed to have been made by Mr. Harris. He would also be testifying to the magistrate about specific things that he told the magistrate that he observed in his investigation of the case. Also would be talking about statements that frankly I don't know where they came from. But that's why I want to ask, is why did you tell the magistrate certain things, pieces of evidence were in fact true? And the answer may very well be, I don't know. Either I made it up, or I don't know where it came from. I cannot delineate someone. So to that extent, I don't believe that would be hearsay either. Well, I know it wouldn't be hearsay because he's the one who actually stated it. So that's what we want to go into with him also, and I think the court's indicating certainly I can call him to testify about his particular actions in execution of search warrants in this case, and ultimately his signing off on return of search warrants that were issued in the case.
Well, I haven't told you what you can ask him about. I have told you that I have not precluded him from being called as a witness. That's up to you. And where I've granted the motion is, as to the search warrant, his knowledge is one thing. Hearsay to him by others is hearsay, and it's not admissible. And even if his conduct is based on hearsay, The substance of the hearsay is not admissible. He can say, I spoke to someone. After I spoke with them, I did X, Y, Z. I know I've already sustained at least one objection along those very same lines and that very same direction that I seem to think may have been a defendant's objection to hearsay. And I didn't let the witness go into the content of the hearsay that caused the behavior. So I'm going to be consistent with that ruling. So follow I'm granting the motion in limine, follow it as best you can, object as best you can. Let's send the poor jurors in and out as we need to if it comes to that point. I hope not.
Well, if I may, let me offer to the court very specifically some of the information that I would solicit from Detective Murphy regarding search warrant information, and the court can advise if that fits within the court's ruling or not.
I'm not.
Or I can ask the question when it gets out here. We'll see. I just want to make sure our proffer is very clear as to what, I guess if the court sustains another objection, then we'll put the proffer specifically at that point in time.
Well, that's one way you can do it.
Or I can do it now. I'm happy to do it right now.
Well, so far when you've done it, it hasn't been particularly clear or concise not to be, I don't mean that rudely, that's just my opinion.
I got it.
So, it's really your decision.
All right. Well, then I'll go ahead and do it now.
But I'm not gonna rule on these things in advance, because my function is not to give opinions,
Understand?
so that's complicated.
I think it's incumbent upon me to make my proffer, to
Well, I
make it
don't
very
mind-
specific.
I don't mind you making a proffer. I'm just thinking maybe you should do it after the fact, not before, because you don't know what you're gonna get in.
Well, I'm happy to call the witness, and we'll take it up when we ask the question and see if there's an objection. That's my preferable way. The state's filed the motion, and the court wished to hear it at this point, so I'm trying to address it.
I know, it's complicated and unusual.
Certainly.
No problem with that.
All right.
So I'll take it then you intend to call the witness, see what happens, and then go from there.
Yes, ma'am.
That's fine.
Thank you.
But remember, I've granted the motion in limine. It's your obligation to do the best you can to follow it. So it's got to be a legitimate question in your mind, which I know it will.
I'll do the best I can. Thank you, Judge.
All right, anything else before we bring the jury in?
No?
No.
Jury in.
It's all right for the jury. Please be seated.
All right, we're ready to proceed with for the defense. Call your first witness.
Defense calls Roger Webb.
Inside the door. Get some to the back. Stand, take your chair. Go.
Good afternoon, Mr. Webb. Please state your name and spell it for the court reporter, please.
Okay, it's Roger Webb, R-O-G-E-R-W-E-B-B.
And Mr. Webb, do you know Ross Harris?
I do.
Okay. And how did you come to know Ross Harris?
I knew him through, I'm a licensed Georgia real estate agent, and he had leased a home that I had had for lease for a client, and then he had reached out to pursue my services for helping him find a house in the Atlanta area.
And when did you first help him lease a home?
Back in 2012,
Okay. And do you know where he was coming from?
Alabama.
Okay. Was he married at the time?
Yes, sir.
Okay. Do you know how Mr. Harris found you?
Not sure, probably through, a lot of times when you have rental properties and you put them out there through Zillow or Trulia or some of the main sites, I'm sure it was found that way, and I was contacted by Mr. Harris and set up an appointment to meet him back in 2012 to lease the unit.
Okay. Now, we've heard some testimony about the Harris's condo in Marietta. Are you familiar with the address 1212 Winds Ridge Circle?
That is correct.
Okay. And is that the condo that you set up for the Harrises that you had set up for them to rent?
Correct. We had several applicants for that property.
Okay. And how did you communicate with Mr. Harris?
Probably via cell phone and email.
Okay. And was email primarily the mode of communicating between you and Mr. Harris?
Yeah, I think so. More than likely, yes.
Showing the witness was been pre-marked for identification purposes, and I've already given the state an opportunity to look at these. This is defendants 93, 94, 95, 96, 97, and 98. Mr. Webb, do you recognize these?
Yep, they're mine.
These aren't all of the emails that you and Mr. Harris sent over the years. Is this representative of the emails that were sent between you and Mr. Harris?
Yes.
And are they fair and accurate copies of the emails that were sent between you and Mr. Harris?
Yes, sir.
I will move defendants 93 through 98.
No objection.
Admitted.
Mr. Webb, we're not going to go through every single one of these emails, but if you'll take a look at the, and I'm sorry, it was 99 included. This last email marked as defendants 99. Is that also a fair and accurate copy of the email that was sent to you on that date and time?
Correct.
I'll move D99.
No objection.
Admitted.
Mr. Webb, moving to when you helped Mr. Harris and his wife find an apartment for them to move into in March of 2012. Did you know the landlord of this apartment?
I did.
Okay. And who is that?
Joe Saney.
Okay. Can you tell us a little bit about your relationship with
Sure.
Joe Saney?
Me and Joe were partners in some Smoothie King franchises early on, and in the 90s, and then we decided to go different paths and sell our stores, and he ventured into insurance, and I ventured into real estate.
Now, were you asked at some point in time to represent Ross Harris and his wife Leanna in the home buying process?
Yes.
Okay. And when was that?
That was 2014, I believe, 2013. I'm not clear on the exact email dates there.
Okay. And did you meet with Ross and Leanna in February of 2014?
I did.
And what was the purpose of that meeting?
The purpose of the meeting was he wanted to set up a meeting in our office to talk about certain specific areas in Cobb County that were important to him and very specific in his home search and finding homes that were in a good school district.
And when he and his wife Leanna came to you in February 2014, what kind of homes were you looking for and where?
We were primarily focusing on the Cobb County School District, certain pocket of the East Cobb School District, Pope and Walton High School. They're very well-known schools, excellent test scores. That was very important to him. He relayed that information to me as far as being specific. He wanted to make sure that we were in his budget, and we were trying to figure that out at the time. But the school systems were the main focus point.
Now, I want to direct your attention to what's in evidence as Defendant's Exhibit 95. Would you read the email that you sent to Ross and Leanna?
One here on Thursday, January 30th.
Yes, please.
Okay. Hey, Ross and Leanna, absolutely, be more than happy to meet and go over everything. Let me know a good time and day next week or whenever, and I will make that happen. I lived my entire life and closed millions of dollars in the East Cobb market area. I know it extremely well. Look forward to hearing back from you. Joe was awesome. He will be happy to know you're leasing for several more months and just put you on a month-to-month basis. Just let me know.
Now, where did you meet Ross and Leanna?
I met them initially when he wanted to see the condo when he was transferring, I guess reloading from his job, from what I understand, from Alabama with Home Depot. And we met at the condo, and I showed him that condo.
And I apologize, I wanted to know where you met with Ross and Leanna in February of 2014.
February 2014.
I apologize.
At our office in Marietta.
Okay. Is that typically where you meet clients, at the Marietta office?
Correct.
Okay. And were they both present?
Yes.
Okay. Did you know at that time that they had a son?
At that time, no.
In February of 2014, did you know that they had a son?
In February 2014, when we met for the real estate?
Right, to start with?
Yes.
Okay.
Yes, yes, yes.
And was Cooper present?
No.
And how long was that meeting?
It was a lunchtime meeting, so I'm going to say somewhere between 30 and 45 minutes.
Now, these folks in Boone County may not know the area of Cobb County all that well. Can you tell us a little bit about the East Cobb market as far as
Sure.
the cost and
The-
popularity?
Absolutely. The specific area we were trying to target is a hot pocket in East Cobb. It's a very desirable area to live based upon the school systems. I attended school there, grew up in East Cobb, so it was very familiar with me. So I had a good idea of what were the best schools, and that's what was important to Leanna and Ross. So that's where I started the conversation and introduced them to the Pope and Walton school districts.
Okay. Did you have to run credit checks and know or get a sense whether they'd be pre-approved for a loan?
Didn't do that in 2014.
Okay.
We had a pretty good idea that they were going to be a pretty solid buyer. A lot of times if we have that feel based upon if a tenant's, and we run credit and background checks when we do leases, and his credit score was superior, and he had a very clean background check, so it was one of those things where we knew down the road that he would be a very solid buyer.
Now, over the course of being in contact with him through email over a couple of years, did he ever talk to you or email you about?
Objection, hearsay. Ask him what the defendant said to him is hearsay.
Did you learn about any possible challenges going on in their marriage?
No.
Okay. I mean, were you aware of any extramarital affairs or activities going on?
No.
Is that something typical that you would talk about with your clients?
No, sir.
Did you set them up on a listing book messenger?
Correct.
Can you tell the jury what that is?
Listing Book is a service that when we try to procure a buyer to become a client, we'll set them up. It's a search engine. It's very specific to the area that they're looking in, price range, bedrooms, school districts. It's an automatically generated email that goes out each morning, kind of keeps the client abreast of what's going on as far as what's selling, and it just gives them a general idea of what's going on in the market area.
Do you remember having any more contact with Ross Harris in the spring of 2014 regarding the home buying process?
After that meeting,
Yes.
I don't believe so.
Okay, can you take a look at
Or,
your emails?
let me,
Let's see, take a look at Vinings 96.
okay.
Was your meeting with Ross and Leanna the day after that email?
Yes.
And when was that email sent, that last email?
Last email was sent, just confirming our appointment at 1 p.m. on February 25th, 2014, at 11:07 a.m.
And what did he say?
I said, "Hey, Ross and Leanna, just confirming our appointment tomorrow at 1 p.m.
And what did Ross respond with?
Yes, sir.
And y'all met the next day?
Correct.
Okay. Now I'm going to show you Defendants 97. Can you tell us what that is?
This is a automatically generated email that goes out from Listing Book that goes into the client's email each morning, keeping them up to date of what houses come to market.
And do you provide them with addresses specific to the parameters that they're looking for?
Correct. They get all the details of active, solds, pending homes, just to get a feel of what's going on in the specific area that a client's looking at.
Okay. And let me also take a look at Defendants 98. Will you read your email that you sent to him on April 1st?
Hey, Ross, just dropping you a line to check in with you. Have you seen anything that I have been sending you through Listing Book that interests you at all? Let me know. Be more than happy to set up something for you to see and get a feel of the type of house you would get for that price range.
And what was his response?
Hey, Roger, we started looking at Ackworth and Kennesaw, just trying to get a feel for the value in schools. I did update Listing Book. We'll let you know if we find something we want to see right away.
Okay. Now, Ackworth and Kennesaw, is that in the same area in East Cobb that you were originally helping them look
No.
around?
It's
Okay.
a little different area.
Why was there a change in neighborhoods?
You get more for your money. The more you venture out from East Cobb, and when you get more into the Kennesaw and Ackworth area, venturing more towards the Paulding County side, you tend to get a little bit more house for your money. And we were looking in those areas and still trying to make sure that the school systems were good in those areas.
Was that still the primary focus?
Yes.
And what was your response?
If you're wanting to be, parentheses, Walton of West Cobb, stay in the Harrison High School District. If you are looking in Ackworth area, go with the Etowah High School District of Cherokee and the North Paulding High and the Paulding County area of Ackworth.
Now, let me ask you to take a look at Defendants Exhibit 99.
Okay?
It starts at the bottom as far as the chronology. Did you send Ross an email in May of 2014?
Correct, on May 19th.
Okay. And what did you say?
Hey, Ross, just checking in with you to see where you are in regards to a purchase. Let me know. Thanks, Raj.
And what was his response?
Hey, Roger, thought I would add Joe, who is the landlord, to this just so he can be immediately in the loop. We're still looking and waiting for a few things job-wise, but trying not to rush into buying. Our meeting was very helpful, and we're putting together a lot of information: where to live, commute, schools, price, longevity, area appreciation, etc. We have a few ideas, so we'll keep you updated.
And what was your response?
Sounds good, Ross. Just holler when you're ready.
Okay. Was that the last time that you and Ross had communicated?
Correct.
And when was that?
This was May 29th, 2014 at 9:26 a.m.
Is it common for you to reach out and follow up with your clients?
Absolutely.
And why is that?
Just, it's important to stay in front of them. We drop emails to all our clients just to keep them in the loop, send them houses. That was the main objective that we have the listing book. It engages buyers daily, sellers too. It keeps our name in front of them, so when they're ready to buy, they use us.
Thank you, Mr. Wood.
Good afternoon. Do we talk, one of the reasons you want to keep in touch with your clients too, you got to make a living, right?
Yes, sir.
All right, so it's good for you to stay in touch with them, keep them up to date, so you know if you've got somebody that's really on the cusp of wanting to go buy a home, you can be there for them. And you've got everything that you need and they have everything that they need, correct?
Correct.
Okay. I know that as far as you worked with the defendant on, I guess, getting that lease, and then initially in February of 2014,
Correct.
discussing house purchasing, correct?
Correct.
Okay. And all that you knew about him personally and observing him was just from maybe, how many times did you meet with he and his wife?
I met one time initially when we leased the condo, when I showed it to him. And then I reconnected again with him when we met in the office, in the Marietta office, to discuss about buying property.
So the last time you'd had any, I guess, face-to-face contact with him would have been February 2014.
Yes, sir.
And his child, Cooper, was not there at the time, correct?
Correct.
So basically, everything you knew about him or your perception of him was just based solely upon the way he portrayed himself to you, correct?
Sure, absolutely. He, portrayed himself as a buyer.
And as Mr. Rodriguez said, he didn't say anything about extramarital affairs or prostitutes or underage girls or anything like that at the time, right?
Yes, sir.
That would have been kind of crazy if he'd have said that to you,
Yes,
right?
sir.
So if he had this other side of his personality, he obviously kept that hidden from you, correct?
Sure, he seemed very normal and very typical of any buyer that would come in the office.
Now, we talked about, Mr. Rodriguez asked a little bit about the Walton and Pope school districts, correct?
Correct.
And that they're highly sought out in
Correct.
Cobb County. A lot of people want to live in East Cobb, right?
Absolutely.
It's pretty much a status symbol, wouldn't you agree?
Absolutely,
Yeah.
based upon the schools.
So, exactly. And so, for your perception and status, it's good to say, I live in East Cobb, correct?
Correct.
Now, as this buying process went along, I guess it appears from what we're saying, or what has been discussed here, that the defendant moved his eye away from East Cobb because it didn't seem like that was going to fit their plans, correct?
Correct.
So moving from that, I guess, higher status symbol and higher perception, good perception area, he had to move out a little bit further from that area to Ackworth and West Cobb,
We were
correct?
exploring those areas because you can get a little bit more for your money and still stay in a pretty good school district.
So basically, for what he wanted to get, it wasn't going to fit in his plans to try to buy an East Cobb, correct?
He could, it was just, he was weighing the options of, in that mid 200 range, when you get in the East Cobb area out there,
Yeah.
you're gonna get a 70s type, maybe a contemporary, something that's maybe not updated. As far as when you push out further, you might get a little bit bigger of a house, you might have a little bit nicer of a house, and, but it was still important. The school system was the main focus of everything.
And so moving out further, that also gets you, I guess, further away, you have a further drive, things like that. Would you agree with that?
Yeah, sure, yes, depending on where your job's located.
Right, right. You stated, we talked about the fact that he got pre-approved and things like that, credit scores and things of that nature.
I was never pre-approved.
Oh, I'm sorry, I did, I
I
missed
just wanted to correct that,
Yes.
because sometimes we won't go down that road initially with a buyer, just because if we have a good feel about them, based upon what we saw with his background, we didn't want to push that, show a couple of houses, then introduce people to the lender. It's not, we didn't want to, we try not to pressure people.
Yeah, and it's a lot of paperwork too to go through that process too.
Correct.
Right? Okay. Did you have any idea that he was actually, I know you checked where they're working, things like that. Were you aware that of any problems he was having at work? Okay. Did you have any idea he was looking for a new job that he didn't actually get in May?
No, sir.
We talked about you talked about a little bit these listserv emails. Now, so he was basically getting emails maybe every other day or
Should have been getting them every day.
Every day.
Listing book set up to engage the buyer daily. Every morning you open up, it comes to the email, and there'll be a list of houses that, and the buyers can adjust that criteria, specific to them.
And when they get the email, all they got to do, they click on something if they're interested.
Absolutely. Click, open it up, and then everything's there, things that have hit the market recently or things that have sold, so they can get a good idea of what's happening in that particular area that they're searching in.
All right, so they see something they're interested in, they can research it further by clicking on it and learning about
Absolutely.
it. Did he tell you anything that in searching for houses with floor plans that had hidden rooms were important in any way?
No, sir.
Okay, so if he had searched for floor plans with hidden rooms and things like that, that would have been something that he didn't share with you, correct?
Correct.
Now, you emailed him in, I think there was some conversation back in January, then you met in February.
Correct.
And then on April 1st, you followed up with an email, one of those emails you got up there, just checking in with him because you hadn't heard anything definitive from him about his interest in going to buy a house.
Sure.
Okay. And when you did check in with him, let me see
Yep.
which email that is. Their format's a little bit different. Okay. He said, hey, you dropped me a line to check in because you hadn't heard anything from him. Obviously, he could have contacted you if he was like, hey, I'm interested, let's move now, right?
Yeah, but a lot of buyers, just with the process, email is very, very common, email and
Right.
texting.
And he could have emailed you at any time between then if he found something and he was like, I want to move now.
Sure, like if he would have identified something and said, hey, let's go look at something,
Okay.
we could have got right on it.
All right. And you didn't get any email from him up until that point on April 1st when you sent it to him, correct?
Correct.
And then he emailed you back, said, we started looking now at Ackworth and Kennesaw, trying to get a feel for value in schools, updated listing book, and we'll let you know if we see something we want right away.
Absolutely. Yep, that's correct.
All right? And then you sent him that email about the school districts.
Yes.
So after April 2nd, you didn't get any more emails or calls from him after that, did you? Until you again emailed him in May.
I believe so. I believe that's correct, how the emails are there.
And in May, on the 19th of May, having not heard anything from him since early April, you said, hey Ross, just checking in to see where you are in regards to a purchase, let me know. Because obviously, you got somebody who says they're interested in buying a house.
Sure, yeah, we're going to stay persistent and touch base.
And so the 19th email, he emailed you back like 10 days later, on May 29th, right?
So that would be correct.
Yeah, that looked right.
Let me see.
It's unfair for me to just ask
Okay,
you
yeah,
to remember
absolutely.
without looking at
So, yeah, so May 19th, and then he responded back on the 29th.
it. Okay, so
Yes,
10
sir.
days later, he responds back. And he didn't respond back, yes, I know exactly where I want to live, I'm ready to go look at houses now. That's not what he responded, correct?
Correct, you got the email, I guess, sir.
He said he wanted to add Joe into the loop because I know he was doing month to month.
Yeah, Joe, exactly.
And he wanted to keep Joe in the loop because obviously from this email, he wasn't looking to move immediately and he'd have to keep Joe in the loop because he's still going to be leasing that condo, correct?
Correct.
Okay. So this wasn't something he's rushing out and going to buy a house immediately, right?
It's correct, everybody's different, yes, sir.
Okay, and he said, we're still looking and waiting on a few things job-wise, but not trying to, excuse me, let me get it right. We're trying not to rush into buying, right?
Correct.
Okay. And that was May 29th, and you never heard another word from the defendant again. Basically, you never heard from him again, correct?
No, sir.
Okay. All right, thank you, sir.
Mr. Webb, you wouldn't consider Ross a friend, would you?
No, sir. Client.
He was a client. Okay. Mr. Boren asked you about all of the emails from Listing Book. The emails that we talked about, those aren't all of the emails that went on between Webb Real Estate and Ross Harris, correct?
Correct. There was also the listing book things that were getting automatically generated as well.
So there were a lot of emails, right?
Correct.
Did anyone from the Cobb County Police Department ever call you, contact you?
During that time?
Yes, sir.
No.
Thanks.
Those other emails that go out from your website, can a person purchase a home just by getting that email? Or does he have to actually talk to you and go out and look at a house and buy it? He can't just click on something and go, oh, I bought a house, right?
No, he'll click on it, and if it's something that he likes, he'll then contact me to go look at it.
All right, thank you.
Thank you, Mr. White.
Your feedback. Next witness.
We call Detective Sean Murphy.
Watch this. This way. What was your name? Bailiff, okay?
Yes.
Have a seat, please.
Good afternoon, Detective Murphy.
Good afternoon, sir.
If you would, just introduce yourself to the ladies and gentlemen, giving us your full name and your occupation, please, sir.
Sean Murphy. I'm currently a detective with the Cobb County Police Department Crimes Against Persons Unit.
And will you spell your last name for the court reporter, please, sir?
Murphy.
Very good. And how long have you been with the Cobb County Police Department, Detective?
I've been with Cobb County almost 10 years now.
Very good. And how long have you been in your current position as a detective?
As a detective, I started in March of 2014, so it's coming up on 3 years.
Very good. And prior to that, what were your duties with the Cobb County Police Department?
Prior to that, I worked as a beat officer and then a field training officer for about 5 years before I went to detectives.
When you say a field training officer, what does that mean exactly?
You're responsible for training new officers or recruits when they come out on the road.
All right. And had you had prior law enforcement experience before coming to Cobb County?
Yes, I did. I worked for Atlanta PD for 3 years prior to coming to Cobb County.
So all totaled, as of today, how many years do you have in law enforcement?
Almost 13 years.
Going back to June 18th of 2014, you were working as a detective for the Cobb County Police Department, correct?
Yes, sir.
And on that occasion, you came to be involved in this case involving the death of Cooper Harris, is that right?
Yes, I did.
Explain to the ladies and gentlemen how you came to be involved in that.
On June 18th, I was actually riding with Detective Stoddard. We were doing a follow-up on a different case, and the call came out regarding a 911 call, and we were notified by supervision regarding the incident, and we had responded to the scene.
And when you responded to the scene, was that at the Acres Mill location?
Yes, sir.
And when you got there, were there other law enforcement officers already on scene?
Yes, there were several uniformed officers, and I believe one or two other detectives, but they had arrived right around the same time we were calling out.
And were there some civilians around the area as well?
Yes, there were.
Very good. And you said you were riding with Detective Stoddard. At some point in time, did you become aware that y'all were going to be assigned this case?
Yes. I don't know if it was through the phone or when we arrived on scene, but in the very beginning of the investigation, we were notified that Stoddard was going to be the lead and I would be his second. Generally, I'm sorry, I'll let you ask.
Go ahead.
Generally, in a homicide investigation, there'll be a lead detective and then there'll be a second detective assigned to assist.
And just explain, ladies and gentlemen, when you assist as a second detective, what sort of things might you do?
I mean, it depends on the case, but generally, because a lot of these investigations are very involved, you're usually either assisting with interviews or doing court orders or search warrants, that type of thing, which frees up the lead detective to focus on other more main issues with the investigation.
And do you continue to work in hand with the lead detective, or do you just kind of send off to do your own thing?
Now, for the most part, we work hand in hand. At times during the investigation, I'd be assigned to go do a couple interviews or get court orders, search warrants, while Detective Stoddard would do other things. But for the most part, you're trying to work hand in hand.
And do you recall when you first became, you said you weren't sure if it was a phone call or when you got there, was it on June 18th that you were informed that y'all were investigating this as a crime?
Yes, it would have been on the way or within minutes of us arriving on the scene that it was decided.
All right. And as you got on scene, what did you do first?
Well, when I arrived on scene, briefly spoke with some of the officers and other detectives. I figured out who was going to handle it. And from there, I took a quick look at the vehicle and the scene, and was directed to two witnesses by one of the officers and interviewed two witnesses at the scene.
All right. Were these civilian witnesses?
Yes, they were.
All right. And did you interview any other people there at the scene that
At the
evening?
scene, no, just once I had spoken to those two, I was notified by my detective startup that Mr. Harris was being transported to our office, and so we went up there for the interview.
When you got on scene, do you remember seeing Mr. Harris there?
I remember he was in a patrol car. I don't know if I really saw him or just was directed to, that's where the car is with the subject inside of it.
You did not go and have any conversation with him yourself?
No, I did not speak with him.
And when you were on the scene and then ended up leaving to go back to the headquarters, how long, do you have any idea how long it was that y'all were on scene?
I can't specifically say, probably maybe 30, 45 minutes, if not less.
Okay, very good. Certainly, not more than an hour at least.
No, we weren't there for an extended period of time.
Very good. And you immediately, within an hour, you went back to headquarters where Mr. Harris was being transported, is that right?
Yes, sir.
All right. And when you got back to headquarters, did you participate in the interview with Mr. Harris?
No, sir, I did not.
Now, what did you go to do?
I was asked by Detective Sire to get a search warrant for his residence.
All right. And explain to the ladies and gentlemen, when you go about getting a search warrant, how do you do that?
For the way we do a search warrant is you basically have to type up an affidavit, which is your probable cause, describing what you want to search, why, and just laying out the facts to the judge. And then we have, it's called the EWI system, which is kind of like Skype where you can talk on the computer. So I'll give him all my information with the affidavit. He'll get it, review it, and then he'll contact me through this video conference where I'll speak with him regarding the search warrant.
And this system is actually set up in your office in the Cobb County Crimes Against Persons office, correct?
Yes, it is.
All right. And so it doesn't require you to go to the courthouse, you can just sit there really at a desk in front of a computer doing it.
Yes, we have a specific computer where you can do it. It's not you can't just do it in any computer. It's a specific computer for that system.
Where is that computer located?
It has currently been moved.
Okay. Where was it located?
At the time, it was, I guess when you, I figure out how to describe it. Basically, we have a bunch of cubicles. Our office is divided into two, at that time it was divided into two sections, robbery and homicide. And the computer was on the homicide side, which had been up against a wall, and our cubicles were kind of behind it going up to the next wall.
This area where the homicide detectives are, you mentioned some cubicles. The entire area where all the detectives would be, is it as big as this courtroom?
Not necessarily this big, maybe take out some of the back space over there.
All right. So if you were in there and needed to talk to one of the other detectives in homicide, you could speak loud enough and they could hear you if they were in there.
Yeah, I'd say is if you're looking at, the computer would have been right here, and then a row of cubicles and another row of cubicles, and that would be the wall over there.
Very good.
So you could yell or stand up and try to yell over, there's walls with the cubicles, or yell over the walls with the cubicles.
And when y'all got back to headquarters, do you remember if there were any other detectives there other than the two of y'all?
Yes, there were other detectives there.
And do you remember who they were, or who you remember seeing at least?
I know Detective Waldorf with our children's, he assisted with the interviews. There was another children's, either a supervisor or detective that arrived there. I know Lieutenant Farrell at the time, Captain Farrell now, and
Was he there at the headquarters?
he had, when we got there,
Right.
I want to say when we got back, I can't I'm just trying to go through who I remember being there while I'm
Absolutely.
taking the search warrants.
Fair enough.
Would you want me to describe
that's-
that, or
yeah,
because I couldn't tell you who specifically was there, and then,
People are coming and going, obviously, and you can't
Yes.
account for them, of course. But let's talk specifically about Lieutenant Farrell. Did you remember seeing him on the scene?
he was on the scene and eventually came back to the office.
Very good. And is his role kind of supervising y'all to make sure you're doing what you need to be doing, or is he just kind of go in his office and leave y'all alone?
Now, something like that, he's going to be overseeing it, and
Hands-on?
I don't know if necessarily hands-on, but he's going to know what's going on.
Fair enough.
He's going to be involved to that extent where he knows who's doing what and.
Is he able to give his input to you and Detective Stoddard as far as anything he may want to?
Yes, he would.
Very good. Now, the interview of Mr. Harris, y'all did not transport him to the headquarters, correct?
Now, he was transported by a uniformed officer.
And were you there when he arrived, was brought to the headquarters?
I want to say he'd arrived before us.
Fair enough. And did you ever see him in the interview room?
In the beginning, I remember seeing because the way our interviews work, it's video and audio recorded, and we could watch the videos from our desk.
Could everybody do that from your desk?
All the detectives could, yes.
Okay.
I mean, necessarily, if they're currently watching it or not, they can. But I remember looking at it and seeing him in the room prior to the interview, and at that point, I was told to obtain a search warrant and started working on that.
Very well. And were you present, were you watching before his interview when he was breaking down very emotionally in that interview room?
No, I didn't. That day, I did not see any of the interview.
Okay. And were you the person responsible for actually turning on the recording device in that room?
I don't believe so, but I can't say for certain if I did or not.
How is that done?
You would log in, someone would have to log into one of their computers and basically just type some information in for the case and hit the record button for whatever specific room we're going to use.
So have you seen the video of the interview itself?
Yes, I have.
All right. And so having seen that, somebody had to have logged in to start that process, correct?
Yes.
And is that something that anybody could have done from any of their computers?
It could have been any detective, and quite often it's someone that might not even be involved in it. They're just trying to help you out by doing that aspect of it.
Okay. Do you remember at all, as y'all got back to headquarters, seeing anybody do that?
Specifically, no.
Okay, fair enough. And when Detective Stoddard and you got there, obviously you two went two different directions. You recall when that was?
It would have been prior to the interview starting or just after it started, because initially we felt like I was going to be involved in the interview, and then it was because the children, if there's a child involved, our children's detectives would get involved in it, and it was decided that the children's detective would sit in with them, and at that time it was advised by me that, hey, we need to get a search warrant for the residents, can you work on that?
And so that's why Detective Waldorf's in the room as opposed to you being in the room?
Yes, sir.
Fair enough. Now, when you get a search warrant, do you actually have to swear under oath to give testimony for a search warrant?
Yes, you do.
And explain to ladies and gentlemen, how do you do that?
Basically, just the way I just swore here, the judge would have you raise your hand and you swear to tell the whole truth and nothing but the truth.
Very good. And even though it's not in a courtroom, it's still a very solemn oath that you take, is that
Yes,
correct?
sir. Yes, it is.
Very good. And did you then, that night, did you obtain multiple search warrants?
That evening I obtained 4 search warrants.
You indicated the first one was for the residence of Mr. Harris, correct?
Yes, sir.
And was the next one also for the residence or something?
Yes, the next one we had expanded the scope on the search warrant, that was also for the residents.
All right. And then the third one was for?
Third one was for his vehicle,
Okay.
and then the fourth was for the cell phone he had with him at the scene.
Very well. All right. Now, as you go through the process of obtaining a search warrant, you mentioned being in front of a computer, you mentioned a judge being involved. Are you actually able to see the judge?
Yes, it's basically, if you've done Skype or anything of that matter, there's a small box in the corner screen and you could see the judge, and I'm assuming his screen is the same as yours, he could see you.
Very good. Now, I want to be real careful here and just want to ask you what you said, okay, what you talked to the judge about, okay?
Judge, I have an objection to that. I think you've already heard that and ruled on that, so I would renew my objection. What he said is irrelevant. You've already ruled on that motion.
I sustain the objection.
When you sat down to get that search warrant, the first one that you did,
Yes, sir.
do you remember how long it took?
Not specifically.
Okay. Do you remember if it took even 10 minutes?
Judge, I'm going to object to relevance. It's not relevant.
Sustained.
Let me try one up. As you sat in that position, that computer, were you, between the different warrants that you applied for, did you get up and take part in the investigation anyway, or were you just kind of doing one right after the other?
Pretty much one right after the other, because you'd have to type one up and create a new search warrant when you apply for a new one.
All right. And when you say type one up, just so ladies and gentlemen understand what we're talking about, what do you mean by that?
Judge, on Jet, again, what he types and what he says is not relevant. You court's already ruled on this.
Your Honor, his investigation, I believe the court's going to allow me to ask about his part of the investigation, and I'm simply trying to find out what that is.
I sustain the objection.
Can we take up a matter outside the presence of the jury, Your Honor, please?
No, you can do it. Go ahead and get through it, and then we'll clean it up.
All right. That night, you know how long you were at the Crimes Against Persons office that evening?
It would have been into the next day.
Fair enough. And you said, you told us about 4 warrants that you obtained. Did you obtain, was that all that you obtained on that evening of the 18th?
Yes, sir.
All right. And on the 19th, after you, well, did you even get to go home and get some rest?
Yes,
Did you
I
have to
did.
get back to work?
Yes.
And when you came back to work, what was your next step in the investigation?
The next morning, I went with Detective Stoddard to the autopsy at the medical examiner's office.
Very well. And after that, did you then proceed to start interviewing some folks?
No, I believe let me check. Directly after the autopsy, I secured several more search warrants.
Okay. You remember?
We kind of went our separate ways at that point. Detective Stoddard had some other investigative things he needed to do with the case, and I went back to securing search warrants.
Very good. And do you remember how many warrants you obtained at that point in time?
I don't know if it's relevant how many warrants you got or anything like that. That's all a prior hearing that we've done before the court. It's not relevant.
I sustain the objection.
All right. Did you do anything else to investigate this case other than obtain warrants?
Referring to that day or overall?
Overall.
Yes, I interviewed several witnesses, co-workers.
Very good. Well, that's a great place to start. Co-workers of Mr. Harris you interviewed?
Yes, sir.
Who were those folks that you interviewed, please?
Give me 1 second.
Sure.
I know it was Winston Milling. Most of these interviews were done with Detective Stoddard.
Very good.
Winston Milling, trying to go through my list on this one.
Alex Hall, were you interviewing him?
Yes, Alex Hall.
Okay.
We went to the Home Depot office, interviewed several employees there. It was Likely, Grant, Moore.
I'm sorry if you'll slow down just a
I
little bit.
just have the last names listed here.
Okay.
If you want me to refer to my case file, I can give you the full.
Is that Miss Likely?
Yes, Miss Likely.
Okay. Do you know, was she a worker there at Home Depot?
I believe she was like not his first line supervisor, but second line supervisor.
Okay. And then someone named Moore?
Yeah, Mr. Moore, Mr. Grant, you have to apologize for me for the pronunciation, Saline, Salian,
Okay.
and Mr. Teen, Etienne.
Etienne, maybe?
Etienne, yeah.
Jelani Etienne?
Yes.
Excuse me, Etienne. Okay. And these were persons who actually worked around Mr. Harris?
Yes, sir.
Okay. Did you actually go to their location where they were?
Yes, we had gone to the Home Depot office and spoke to several of those.
Did you actually see Mr. Harris's work area?
Yes.
All right. You know, these other folks you spoke with, is this also their work area?
Yes, we tried to interview the co-workers that would have been seated directly around him.
Very good. And just describe that area a little bit, please, ladies and gentlemen.
It's been a while since I've seen it, but it's from what I remember, it's just basically a box cubicle with several desks kind of in a circular around this box cubicle, where you're not basically inside of a wall. You can turn around and see the person. There's very short walls. You can turn around and see the person next to you or behind you.
Did you actually see Mr. Harris's cubicle as well?
Yes, I did see his cubicle.
Do you remember being present or seeing some pictures being taken of that area?
I don't recall if I was present or not when that occurred.
Okay.
I don't believe we took any pictures that day, but I can't be for sure.
That's right.
I wouldn't have been the one that took the pictures.
Fair enough. And that's not part of what you would have to do. That's a crime scene person to arrest.
Detectives can do photographs and stuff of that nature. Very good above that detective.
Fair enough. Do you remember in looking at Mr. Harris's cubicle, seeing some mementos up on the wall around his desk?
Honestly, I can't remember. I just generally remember the surrounding cubicles and what it looked like.
Fair enough. That space, are we talking about a, kind of a small space, all those people working together as well?
I know it was kind of a bigger room, but
Okay.
as far as that space, it's hard to describe. Maybe like, as far as the courtroom right here, this area would be maybe
Well,
half
or
of
the
that,
court? Okay.
or a third of that.
I'm standing, maybe 10 feet from you, give or
I'd
take?
say maybe from you to the wall there.
Okay, all right. So.
Again,
and-
this has been a while, this is a while ago when I was.
I understand. So the number of coworkers you spoke to there was, you gave us several names, but I don't know if we delineated all of them. Those who were in that space, we're talking about 4 to
Yes,
6
those were the ones I
people?
would have spoke to on that particular day that I gave you, besides the first two.
Uh-huh,
It would have been Wednesday, 6/25/2014. And I believe I spoke to, give me 1 second, it was a phone call. I want to say it's Andre Brown,
okay,
and I spoke to his direct supervisor, but he doesn't even work in the same building. I believe he's out of state.
okay. You mentioned Christiane Likely,
Yes,
Pramod, Pramod Salian,
yes, sir.
Jelani Etienne you mentioned,
Yes,
and all those folks are right there, right in that cubicle area, is that correct?
yes, I believe Andre Brown was as well. He was talked over the phone at a later date.
Very well.
And there was a Regina Mallory,
Okay.
who, flight down officer. She worked in the same building. I don't know where her desk was.
Could that possibly be Regina Malloy? Or do you
It
believe
could
it's?
be. I might have the wrong spelling.
Okay, all right. Yeah, I think you mentioned a Brandon Moore.
Yes, sir.
All right. And after being there, did y'all take any items from that location, from the workspace? On that first day at least?
Nothing that I remember.
Fair enough. And were you ever a part of obtaining any other items from the Home Depot, the treehouse area?
The treehouse specifically, I don't believe so. I did go there to serve several search warrants.
Very good. And so if you went there to serve them, was there just nothing taken from that location that you recall?
I believe that mainly it was me handing them to somebody to serve them. And I think on one occasion I did go to pick up a disc.
I got you. They were going to be getting stuff together and then providing it back to you
Yes.
all? I got you. And the Home Depot corporate office, did you ever have any involvement in going over to that location that you recall?
Yes, I did.
All right. And Mr. Milling and Mr. Hall, is that where you would have interviewed them maybe?
I believe Mr. Milling was interviewed in our office,
Okay,
and Mr. Hall was interviewed at the Home Depot corporate office.
very well. All right. Do you remember speaking to anybody else over at the Home Depot corporate office, interview-wise?
As far as, I remember speaking to several, I guess it'd be corporate security
Right,
or like video technicians.
very good. And did you obtain, you said you talked to some video technicians, were you speaking with them in order to obtain some of the videos that we may have seen already in this case?
The detective starter was more involved with that. This would have just been occasions when I was there with him where we went and spoke with them.
Were you ever there at some point in time to observe the surveillance system that they have at Home Depot?
Yes, I did see it on one occasion.
And did you have any involvement in investigating as to the timestamp on those videos as to the accuracy or lack thereof of that?
No, I was not involved in that.
And were you present at all when that question would have been raised?
I don't believe so.
All right. Leaving that area, did you have occasion to go to the residence of Mr. Harris?
Yes, I did.
And would that have been that very first night after you got the search warrant, or 2 warrants for that location?
No, sir, this was another search warrant that we did on the residence.
Do you remember when that was?
The search warrant or when I went to the residence?
Oh, when you went to the residence?
Give me 1 second, I'll give you the date. It would have been June 30th of 2014.
Very good. Now, when you went to the residence on June 30th, was that pursuant to a search warrant that you had obtained as well?
Yes, sir.
And what was the purpose of going to the residence on that occasion?
The purpose of that particular search warrant was, we were looking, it was two things. We were looking for any financial records or anything of that nature, but also for the light bulbs that he had purchased at lunchtime.
When you say the light bulbs he had purchased, were you aware of light bulbs being located in his vehicle?
Yes.
Okay. And what specifically were you looking for at the house?
Specifically, if he had a reason to purchase these light bulbs. Was there light bulbs out in the residence that would match the light bulbs he purchased, given a reason to go purchase the light bulbs?
Okay. And were you the person who actually obtained the warrant for that purpose?
Yes, sir.
Okay. And did you have some expectation that there would not be a need for those light bulbs actually before you went to the house?
Judge, I object to the phrasing of that question. It's argumentative.
I'm sorry?
I sustain the judgment.
Okay. Did you take somebody with you in order to document what you might or might not find at that house?
Yes, sir. I took crime scene tact Shumpert, and also when we do a search warrant, we have to have a supervisor present, so Sergeant Knowles went with me as well.
Very well. And what did you do as far as looking for light bulbs in that house when you got there?
Simply went to each room. These were particular light bulbs that I recognized as being for a bathroom fixture. Went in the room to see if the light bulbs were working or not.
All right. And when you went to this house, did you find that in fact there was a need for these light bulbs?
Yes.
All right. Where did you see that?
I believe it was the master bedroom's bathroom.
And I believe you've seen some photographs of that. Did you have CSC Shumpert take some photographs?
Yes, he did
Document that?
photograph.
All right. And were those the same type bulbs that were actually purchased that day in Mr. Harris's car?
Yes.
When you were at Acres Mill initially, I think you said you kind of looked over at the car. Did you actually look into the car at all and look at the car seat?
No, I never got close enough. I remember walking up to the vehicle, probably several yards, and jotting down what kind of vehicle it was, tag number, in case we needed it later for a search warrant.
I got you. But didn't make any notice of any car seat?
No, I remember seeing a car seat, but again, I didn't get very close to the vehicle.
All right. And did you, after the car was taken into custody, did you have occasion to see it later?
The vehicle?
Yes, sir.
Yes. I can't specifically say when, but we did have it transported to our Evans garage, and I remember looking at it later.
Very good. How about the car seat? Did you ever look at the car seat?
Yes, I did.
All right. And do you recall at any point in time ever seeing the car seat? Well, let me show you some photographs first. States 277, 276, and 279. It's already been introduced. Unfortunately, the car seat's not here right now, so have you look at those photographs. Does that appear to depict the car seat that you observed whenever it was you observed it?
Yes, sir.
All right. And are you able to look at those photographs and tell us which strap the car seat, which hole the car seat straps are set in?
It would be the center or middle.
And when you say middle, that suggests
There's 3 slots, and it's in the middle slot.
very well. And did you ever see that strap anywhere other than in the middle slot?
I don't believe the straps were ever moved, or the reason to move.
Very good. And so you never saw any strap in the lowest slot of this car seat? Is that correct?
According to these pictures, no. I did look at the car seat and was mistaken when I first looked at it.
Oh, I got you. I got you. And did you tell somebody and inform somebody that was set on the lowest level?
Objection, relevance, and hearsay.
Well, it can't be hearsay. He's the one who said it. And it's relevant because it's going to exactly what we're talking about here. State's evidence.
But it's an out-of-court statement. This is an in-court statement we're dealing with now. Any out-of-court statement that he made to somebody else is still hearsay.
And it's obviously not offered for the truth of the matter because he's already told us he was mistaken about it. It's not hearsay.
lowered over objection.
Did you in fact inform someone that it was set on the lowest level?
Yes.
All right. Who was that you informed?
Probably Detective Stoddard and other investigators.
Do you recall giving any sort of testimony to that effect?
Yes.
All right. And was that to the judge?
Yes.
Judge, I renew my objection to
I
Robert.
sustain the objection to that.
All right. You were mistaken. When did you learn that you were mistaken about that?
I can't specifically say when. I believe somebody mentioned it to me, or it was one of the occasions where we were looking at the car seat,
I got you.
and I then realized that it was not on the lowest level, it was in the middle.
All right. Now, as you were going about doing interviews and trying to get information in this case, were you the person who made the charging decision in the case,
As far as, no,
deciding to arrest and charge Mr. Harris in this case?
no.
And in your talking with people, were you interested in hearing whatever perspective people have?
Judge, I object to whether he was interested in that. I don't think that's a relevant inquiry.
I'll rephrase. Did you interview people and offer them the opportunity to give you their perspective?
Referring to witnesses? Or?
That's right.
Yes.
And do you remember talking to multiple witnesses about observations of Mr. Harris there at the Acres Mill location?
Yes.
And do you remember talking to other witnesses about how people act in such difficult situations?
As far as me asking them how you would think somebody would act?
No, I'm talking about what you told them as far as your experience and your knowledge about people in these difficult situations.
Objection on twofold. One, it's still hearsay, and two, it's not relevant what he told other people.
I sustain the objection, Mr. Bowles.
Do you have experience, Detective Murphy, in seeing people in very traumatic situations?
Yes, I do.
And have you seen people react in all sorts of ways in traumatic situations?
Different people react different ways, yes.
Okay. And you certainly never had a case like this that involved a child who had died in a car of this nature, correct?
No, this would be a first.
Ultimately, the work that you did on the case and the interviews that you did, who would you give that information to?
I would forward it to Detective Stoddard, either verbally or it'd be in my supplemental reports where he could read about it.
Very good. And then, as far as what decision, what needed to be done with that information, who would make that final call as to what would be done next?
As far as what's done based on the information that I gathered,
Yes, sir.
ultimately it's up to the lead investigator, but it would, be discussed too.
Very good. And the lead investigator in this case, we know Detective Stoddard was initially. Did that ever change throughout the investigation?
No.
As far as obtaining items of evidence from these search warrants, we know you went to the house. We know you went to the Home Depot. Do you recall any other locations that you went to obtain any items?
I believe I went to, I forget the name, I could refer to my
Sure.
case file.
That's absolutely fine.
Can you be specific? On July 3rd, 2014, I went to the office for Kaiser Permanent and obtained some district pertaining to medical records regarding a search warrant.
Very well.
For, I think it was Cooper and for Justin Harris.
Very good. All right. Were you a part of any meetings regarding looking into this, what we refer to as the red whisper? The whisper about that some person had made about having issues with their children. Were you involved in any meetings trying to determine the source of that?
I don't necessarily know meetings, but I was involved in trying to figure out where it had come from. But I wasn't, I mean, you're referring to the computers, looking at computers and stuff like that, as far as that, for that, no.
Okay, all right. And as far as the looking up information about, were you familiar at all with some evidence regarding a child-free website?
Referring to the Reddit?
That's right?
Yes.
All right. And were you ever made aware as to the source of, the original source of that Reddit's existence?
Objection, that would be hearsay.
I'm not asking what anybody said, I'm just asking if you became aware of that. It's already in evidence.
Well, he can say yes or no to that.
As to, I'm sorry, I guess the question again, I just want to make sure I get it.
Do you recall when you became aware, I think the question was, were you aware of the existence or the original source of the knowledge of this Reddit, the child-free Reddit?
As far as where it came from, or
As
how the defendant got a hold of it?
particularly how it came to the defendant's attention?
No, I was never made aware of that.
I got you. And with regards to the light bulbs that you talked about earlier, did you ever obtain those from the vehicle yourself?
No, I either remember jotting down particular make and model and size of the light bulbs from that, or I obtained that from Detective Stout. I can't remember specifically, but I remember getting that information.
Okay. All right. And okay. And that's all I have right now. I have a few questions in just a moment. Now, to the other matters, we'll, of course, we want to address that with court, proper time.
Let's take an afternoon recess. But keep it up in mind, don't discuss the matter, close enough pads, take a minute.
Let's all rise for the jury, please.
Take a break, and we'll come back and deal with the offers and the other issues.
Thank you.
Not to the restroom.
I thought that was weird.
You can come upstairs with your.
But I tried.